of TCC Judgment 113, Champagne 7, 2024. Case on accruing previous seniority in salary assessment for certified substitute teachers. High notes, Article 35, Paragraph 2 of the Teachers Act as amended July 19, 2000, hereinafter, Provision 1, is constitutional. It is in accordance with the doctrine of specific authorization regarding teachers' remuneration laid out by J1 Interpretation Number 707. Article 12 of the Regulations of Contracted Substitute Teachers and Part-time Substitute Teachers in Elementary and Junior High Schools, as amended August 18, 2014, hereinafter Provision 2, and the Ministry of Education letters Tai Chao Chen 10500097778 of January 26, 2016, hereinafter letter 2, Tai Chao Chen 10500444815 of April 1, 2016, hereinafter letter 3, Tai Chao Xiu Gu 10501211014 of November 3, 2016, hereinafter letter 4 are unconstitutional for violating the division of powers between the central and the local governments under Article 108, Paragraph 1, Subparagraph 4 of the Constitution. Letters 2, 3, and 4. Article 10, Paragraph 1 of the Supplement Regulations on Contracted Substitute Teachers and Part-time Teachers of New Taipei City Municipal High Schools, Junior High and Elementary Schools, as amended November 23, 2011. Hereinafter Provision 3, and the first sentence of Note 3 of the criteria for assessing salary for public schools and preschool substitute teachers issued by Education Department of the New Taipei City Government, hereinafter Provision 4, are unconstitutional for violating the equality principle under Article 7 of the Constitution. Background note. Substitute teacher, either certified or uncertified, are relief teachers who stand in full-time for regular teachers when they are taking a leave or unable to perform their teaching duties. Substitute teachers are generally employed in high schools and lower-level schools, elementary and junior high, which can be further categorized into national schools, private schools, county municipal schools. However, the remuneration guidelines on whether to accrue seniority of past teaching jobs for substitute teachers vary in different regions, levels, and types of school because they apply different regulations, some stipulated by the Ministry of Education and some by local governments. Questions arise as to whether this distinction and additionally the different treatment between substitute and regular teachers violates the constitutional principle of equal protection. Petitioner Mr. Kai-Shan Chang was a certified substitute teacher contracted by New Taipei Municipal Zhonghe Senior High School in 2017. When assessing the petitioner's salary, the school referred to the criteria for assessing salary for public schools and preschool substitute teachers and discounted his seniority also as a substitute teacher in 2 other public high schools. After unsuccessful administrative appeals and exhaustion of ordinary judicial remedies, the petitioner filed for constitutional review. The petitioner argued that relevant regulations and letters violate Articles 7, 15, and 23 of the Constitution for creating different treatment in the remuneration of substitute teachers. The petitioner also argued that the JY interpretation number 707, which rule on the legal authorization of remuneration regulations for public school, including elementary, junior high, and high schools, teachers should be supplemented. This case was argued on March 12, 2024. Judgment 113, 宪判 7, 2024 was announced on August 9, 2024. Justice Chen Dong-Cai wrote this judgment. 2 opinions occurring in part and dissenting in part was filed. 3 opinions dissenting in part were filed. Summary of the judgment. Holding 1. Provision 1 prescribes that the rights and duties of substitute teachers be stipulated by Ministry of Education hereinafter MOE issued regulations. It did not violate the doctrine of specific authorization. 2. Provision 2, Letter 2, 3, and 4 issued by MOE, which authorized the local governments to stipulate supplementary regulations regarding whether to accrue previous seniority when assessing the salary of certified substitute teachers in high schools and lower level schools. The new Taipei City government and its education department amended and issued provisions 3 and 4, which supplemented the regulation on accruing seniority of previous teaching experiences of said teachers. Within said scope, the provisions and the letters violated Article 108, Paragraph 1, Subparagraph 4 of the Constitution. 3. Letters 2, 3, and 4 issued by the MOE, as well as provisions 3 and 4 issued by New Taipei City government and its education department prescribe that when assessing the salaries of newly employed certified substitute teachers, the high schools and the lower level schools may not accrue their previous seniorities. Within said scope, the provisions and the letters violated the equality principle under Article 7 of the Constitution. 4. The parts of provisions and the letters declared unconstitutional in parts 2 and 3 of the holding shall cease to be effective at the least 1 year from the announcement of this judgment. 5. Petitioner may, following this judgment and the relevant legal procedures, motion for a retrial with the court of jurisdiction for his original court case within 30 days, starting on the next day of the date when this judgment was served. 6. The rest of decision shall be dismissed. Reasoning. 1. Provision 1 conforms to the doctrine of specific authorization. Following the decision of JY interpretation number 707, the remuneration of teachers, including the assessment standards of their salaries, is an important matter of public interest. Under said interpretation, it is constitutional to stipulate such matters with regulations, provided they are specifically authorized by the law. Therefore, it is constitutional for the legislators to set out Provision 1 authorizing the MOE to stipulate relevant regulations on supplementary or special matters regarding substitute teachers' rights and duties. The content and scope of Provision 1 authorized were specific and clear, which conforms to the doctrine of specific authorization. 2. Whether to accrue seniority of a previous teaching experience for newly employed certified substitute teachers in junior high and elementary school is a national matter and shall be stipulated with unified regulation issued by the central government. 1. Regulatory framework for the remuneration of certified substitute teachers. Provision 1 authorized the MOE to stipulate regulations regarding the remuneration of certified non-regular teachers, including full-time, part-time substitute teachers in junior high and elementary schools. With the authorization of Provision 2, which was in a Provision 1 authorized regulation, MOE further delegated the competence to lay down supplementary regulation to local education administrative agencies. Additionally, the MOE issued letters 2, 3, and 4, clarifying that the school may accrue previous seniority when assessing the salary of certified substitute teacher upon employment, just as the regular teachers. However, the local government may decide depending on their physical conditions. 2. The central government has legislative discretion over the educational personnel system, which also contains the remuneration standard, including the assessment of salary of certified substitute teachers. Education is the cornerstone of national development. The quality of teaching could indirectly influence the people's right to education. Because teachers serve a crucial role in the education system, the design of teachers' personnel management, including training, certification, rights, and duties, shall belong to the legislative discretion of the central government as required by Article 108, Paragraph 1, Subparagraph 4 of the Constitution. Substitute teachers in junior high and elementary schools are full-time education personnel, just like the regular teachers. Under nationwide factors such as declining birth rate, delayed retirement of regular teachers caused by pension reform, and changes in curriculums that result in decreased teaching hours, local competent authorities have taken action to reduce the number of regular teachers. Their measures led to the increasing employment of substitute teachers who function the same as regular teachers. Many of the substitute teachers also have administrative responsibilities or serve the role of homeroom teachers. From this perspective, if one school denies accruing a certified substitute teacher's seniority of previous jobs at another city or county, when assessing his or her salary, it would have the same effect as the other school enjoying said teacher's teaching experience as elsewhere for free. If this issue is not managed with a unified national standard, it will cause unfair fiscal burdens between the local governments, as well as insufficient protection to the certified substitute teachers, which violates the protection of educational workers under Article 165 of the Constitution. Therefore, whether to accrue a certified substitute teacher's past seniority is a matter regarding the education personnel and the educational system, which belongs to the legislative discretion of the central government. Conclusion 3. The MOE did not issue specific regulation on the accrual of past seniority of certified substitute teachers. Instead, the MOE delegated the competence to stipulate such regulation to the local government with provision 2, letters 2, 3, and 4. This allows the local government authority to decide on their own depending on their physical conditions. This may lead to inconsistent practice and unequal distribution of teachers between regions. Such effects would further affect the people's right to education under Article 159 of the Constitution. The said provision and later did not conform to the decision of J1 interpretation number 707. Within this scope, the said provision and latest violate the division of power between the central and local governments under Article 108, paragraph 1, subparagraph 4 of the Constitution. 3. Letters 2, 3, and 4 and provisions 3 and 4 herein together. The regulation in question, stipulating that the junior high and elementary school may discount certified substitute teachers' seniority from previous teaching experiences when assessing their salary, have violated the equality principle under Article 7 of the Constitution. 1. This case shall be reviewed under the intermediate scrutiny. The regulation in question uses the status of whether one acquired the position of a regular teacher as the criteria for differential treatment. Under such a distinction, the local government may decide if the school should accrue the seniority of a previous job instead of being required mandatorily. Such a criterion is not an immutable characteristic. However, considering Article 175 of the Constitution prescribes that the state shall safeguard the livelihood of those who work in the field of education and shall, in accordance with the development of the national economy, increase their remuneration from time to time. Furthermore, as mentioned but before, J1 interpretation number 707 deemed the remuneration of teachers an important matter involving public interest. The differential treatment imposed by the regulations in question shall be reviewed under intermediate scrutiny. 2. The regulation in question could violate the equality principle, and it was doubtful whether their purpose served an important public interest. The differential treatment under the regulation in question is based on the formative factors of whether one is a regular teacher. In doing so, the regulation in question have neglected that in practice, certified substitute teachers are manpower equivalent to regular teachers. Past teaching experiences of the certified substitute teachers are not properly evaluated under the regulation in question, leading to unequal pay for equal work, which could violate the equality principle. The MOE expressed in letters 2, 3, and 4 that local governments may decide, depending on their physical conditions, whether the school shall accrue certified substitute teachers' seniority of previous teaching experiences. However, the design of education is important for the generation to come. It concerns the overall literacy of the citizen and the national development. Sufficient protection for livelihood of the certified substitute teachers would elevate the quality of teaching. Subsequently, it would also protect the people's right to education and advance education in rural areas. Whether to accrue seniority of the certified substitute teachers should not be based on physical burdens alone, but should also on important public interests such as protecting the right to education and advancing the education in rural areas. It is doubtful whether the regulation in question, which listed the reduction of physical burden as their main purpose, are of important public interest. 3. The differential treatment imposed by the regulation in question was not substantially related to its purpose, even if alleviating the physical burden of the government was an important government interest. The MOE failed to provide accurate statistics to elaborate why discounting seniority could evidently achieve it. The differential treatment imposed by the regulation in question was not substantially related to its purpose. Moreover, the accrual of seniority of certified substitute teachers would work the same as regular teacher because in practice they have already shared almost the same teaching and administrative responsibilities. For conclusion, the regulation in question did not pass the review of intermediate scrutiny. They violated the equality principle enshrined in Article 7 of the Constitution.